Yeah. Yeah. Okay. Thank you. All right. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, give their attention to the court, now sitting.
Please be seated. Good morning. Welcome to the Kansas Supreme Court. I have quite a few students in the audience today as well as some others. Professor Smith, would you like to come forward? Introduce your group to us.
I have a class called Intro to Law. Most of my students are freshmen over at Washburn. We're in the legal studies program. And we're early in the semester, but I've got a lot of enthusiastic students and they're so excited about criminal justice and just the legal system. And so we're very honored to be here today.
Thank you. Well, we're honored to have all of you and look forward to visiting with you more. And are glad you're excited about the law. I hope that you'll consider all the various career possibilities there are in the law, because we need more people that are interested in working within the court system and are in desperate need of attorneys across the state. So there are possibilities there for anyone who is interested in pursuing those types of careers. So love to visit with all of you about that. So my little public announcement of our shortage about our shortage of attorneys in the state. With that, I will ask Mr. Doug Schuman to please call the 9 a.m. docket.
Thank you, Your Honor. May it please the court. The first case on the 9 a.m. docket for Wednesday, September 11th, 2024 is appeal number 123451, State of Kansas versus James A. Willis, Johnson County, briefs both sides.
May it please the court, Kristen Patty for appellant James Willis, present and ready for argument. May I reserve 3 minutes for rebuttal?
3 minutes is reserved.
Thank you.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas, present and ready for argument.
Second case is appeal number 125846, State of Kansas versus Benjamin Ballard, Sedgwick County. Briefs both sides.
Good morning, and may it please the court, Grace Tran of the Appellate Defender Office on behalf of the appellant, Mr. Benjamin Ballard. Chief Justice, may I reserve 3 minutes for rebuttal?
3 minutes granted.
Thank you.
May it please the court, Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. Will the attorneys in 123-451 State of Kansas versus James Willis come forward and settle into their places? I might make a few comments to help explain to those that may be watching online and those in the courtroom audience that may not have seen an oral argument before. Explain a little bit about what happens and what the background is. These cases come to us from a trial court level where there have been proceedings that are trials that occurred there. We get a record, a written record of the questions that are asked of witnesses, the arguments that counsel make, the rulings that the trial judge made. All of those are available to us along with briefs of the parties where, in this case, Mr. Willard and then later Mr. Ballard have argued that the trial court committed errors in during the trials of their cases. We have read all of that material and are prepared now to ask some questions of counsel and to engage in some dialogue with them to help us better understand the arguments that they are making. As we do that, we will consult the notes we've made either on our computers or papers that we have in front of us. But even when we're looking at those things, we are actively listening and engaged in the discussions because it really does help us as we make our decision about what the outcome of the case should be. With that explanation, Ms. Patty, thank you for your patience and please come forward.
Again, Kristen Patty for the appellant, James Willis, who was convicted of first-degree murder, premeditated murder, as well as possession of a firearm by a convicted felon. And we're not really contesting that conviction because he stipulated to it. This case the trial was about 2 weeks long, but what it really comes down to is about 4 minutes in time when my client's brother, Dale, had an encounter with the victim, Jewel Carter, outside a bar where a hip hop or rap concert had occurred. And if you review the record, particularly the closing argument of the prosecutor, it comes down to respect or disrespect. I didn't brief this, but I took all the jury trial transcripts and I put them end to end in Acrobat just to see who used the word respect or disrespect. And nobody seems to have used it more times than the prosecutor in his closing argument. As this was briefed, it was that the prosecutor committed error in closing argument by commenting on facts not in evidence or misstating the facts. He argued that James did not act in self-defense and was motivated by disrespect shown to his brother. But the problem is there was an encounter with a car, which, as we know, can be a deadly weapon. Outside this rap concert, where I think maybe between the two trials, the evidence was inconsistent, but the vehicle may have hit Dale or may have almost hit somebody else.
There's inconsistency there from Dale Willis's trial,
Right.
Which the evidence was that the car did strike or almost strike Dale Carter.
Right.
And then I think it was verified in this trial that Dale Carter was Dale Carter because I'm thinking.
Well, you must be a Chiefs fan.
Yeah. Anyway, Dale Willis was actually inside the club when the incident happened with the car. And I don't know that that matters that much because the altercation took place in the sucker punch, which everyone testified to
True.
took place outside with Mr. Willis, Dale Willis, and the victim. So what's wrong with the whole notion of a state having a theory of disrespect or not respect when that encounter happened? I mean, isn't that what that's about?
I guess the prosecution's evidence just came down to only one witness testified a little bit in that regard. And he did say that, so if somebody disrespects you, especially in a public place in front of people that know you, you're expected to do something about it. But I suppose that maybe he didn't use the word retaliate. But it doesn't really impute motive for murder. A retaliation could have been something quite a bit less than that.
Can't the jury infer though from that testimony that that's what happened here? I mean, he describes an ethos in this community of folks that's how you respond. And why isn't it a reasonable inference from that evidence to suggest that that was the motive?
Because there was no, there's an awful lot, as you know, in the trial about what happened before the 4 minutes that we're talking about. And maybe something that happened in the club between Dale Willis and Tyrone Brown, right? And yet,
Yeah, there may have been conflicting evidence,
Right.
but is that evidence that the state introduced about the ethos sufficient to infer a motive?
to me, it seems like a red herring. It seems like, and I realize I'm stuck with a little bit the way this was argued, or was briefed, but it seems like they're trying to create a fear in the neighborhood type sentiment here. Which, these guys coming over from 29th and Askew, near the Jackson Curve. I went to Shawnee Mission East, so this club would have been in my high school district. We've, at least in my mind, when I grew up 40 years ago, that's quite a different environment. There's no testimony that Dale and Joel Carter had any encounter inside the club. When a defense witness, Antonio Frazier, talks about disrespect, but it's about Carter making statements about disrespect, not Dale or anyone else. So it seems like it's an overstatement of the evidence. And while I might have argued it a little bit differently, there is inflame the passions of the jury at the bottom of page 16. The other part of it was that the prosecutor in closing argument misstated the law on self-defense. He stated that for the jury to find that the shooting was in self-defense, they had to believe that Carter had a gun.
And I am having trouble as I read that in context of seeing how that's a statement about the law versus the prosecutor really focusing the jury on the facts. That nothing else except that testimony from Willis gives a foundation for self-defense. So what you have to do is factually believe Willis to be able to conclude that there's self-defense. Why is that reading incorrect? And if that reading is correct, isn't that a fair statement, a fair argument to the jury?
Well, the evidence did show that there was at least appeared to have been some other gun, because I think there were both 45 and 32 caliber shell casings found at the scene. I think the 45 was the one that James had. So someone else did have a gun. also, it kind of goes back to what we were talking about, the culture of what, of people who were at the rap club that night, that people commonly did use guns. I think that there is some testimony that Dale and anybody who'd been inside, at least who had just come out of the club, they would have had to have gone through screening before they got into the club to make sure that they didn't have guns. But if, since Carter had been to his car and had pulled it up, that provides an opportunity for him to acquire a gun.
Your answers,
All facts.
I'm sorry.
All those things you're arguing are facts,
Mhm.
which to me add to this being an argument about the facts, not about the law.
And I always hate it when I have to argue facts. It's
Can I put the question slightly differently?
sure.
Is there any evidence at all in the record that a justified act of self-defense could have been predicated on some fact other than a gun?
As I understand it, Joel Carter was revving the engine of the car. As I also understand it, he may have been, one place it seems like the car might have been in neutral. I've also seen descriptions that it might have been put in reverse.
So was there testimony that there was a concern or fear that the car was being used
I
as a
don't
deadly
know that
weapon?
anybody testified to that.
Well, you watch the video, it belies that version, doesn't it? I mean, it's a slow moving vehicle that's exiting the parking.
And for, because of when I got this case, I was not able to see the video. But still
You have
somebody,
not seen the video?
but still somebody, I took it over after briefing.
No, I'm not,
Okay. Just because a car is going in reverse, it doesn't mean that it can't be put forward again. And if I briefed it, I might have tried to do something different with that. The second issue, and I'm getting a little bit short on time, is whether the district court committed reversible error in the instructions in the jury. We've kind of touched on some of this so far. They did not, the jury was not instructed on voluntary manslaughter with imperfect self-defense, which would be if the subjective element is present, but the objective element is not. We would suggest that that was factually appropriate, because James did testify that he was in fear for his safety and believed that Carter had a gun. He did, Carter was very agitated, and he was trying to get Carter to calm down. The scene was chaotic.
help me here with, we are in clearly erroneous standard of review. How do you clear that hurdle? Why is this clearly erroneous in your view? Given the nature of the case and the evidence?
Because there was testimony to support that either self-defense or defense of others.
From the defendant, James Willis.
Yes. And
That's what your argument would be, that his testimony maybe would allow for the instruction, but in clearly erroneous, there was a strong evidence.
And certainly, we couldn't argue it, I don't think, without his testimony. There's just the other circumstances, the other witnesses testifying about Carter being aggressive, saying, what was it? Namich, I'm gonna get them, something like that. There's other evidence, but certainly, yes, James actually testifying that he was in here fear for his safety and believed that Carter had a gun, provides some basis for the voluntary manslaughter instruction. And then we also argue that the involuntary manslaughter, imperfect self-defense, was appropriate. because it was, the force obvious would seem to be excessive. And I'm out.
How do you get around the KSA 225226C, which talks about provocation, who initially provokes any use of force against such person? That defense is not available, or that instruction. How do you get around that when it was Dale Willis who provoked the entire incident?
Well, and I guess it would seem like there was also some testimony that Carter was provoking things with his behavior, his aggressive attitude, his intoxication level that evening. So there are no further questions.
Thank you.
Thank you.
Mr. Gontesky.
Chief Justice, and may it please the court. I'm Jacob Gontesky. I represent the plaintiff, the appellee, the state of Kansas. Gerald Carter was shot and killed by James Willis as Carter sought to retreat from what was at most a verbal altercation in the early morning hours in front of a bar in Shawnee, Kansas. The state reasonably argued that Willis shot and killed Carter over a showing of disrespect by Carter. Carter was inebriated, and the two shared words, angry words, out on the sidewalk that morning. And Carter then, after exchanging words, Carter was punched in the back of the head by Mr. Willis's co-defendant, his brother, Dale Willis. And he was dropped to the ground, and he stumbled back up, and he stumbled back into his car, and then sought to retreat from the altercation. And when he did so, he started the car, and as the court is already aware, the car can be seen on video slowly rolling back from its parking spot. The video doesn't show the perspective quite as well, but it's a fairly steep hill in the parking lot down from the sidewalk. And to the extent that a couple of witnesses testified to the engine revving, other witnesses indicated they believed that Mr. Carter was inebriated and he had put the car in not reverse, but in neutral. And he was trying to get away from the altercation and was applying the gas pedal and revving the engine when the car was simply rolling down the hill in neutral. While the car was rolling down that hill, James Willis responded by pursuing Mr. Carter, pursuing that car, the car that contained what he described from the witness stand as a threat to him. But instead of the way Mr. Willis responded to that threat was to charge toward it and unload 11 rounds from his .45 into Carter's car and into Carter himself. The state's argument that that killing was premised upon a showing of disrespect by Mr. Carter to Willis and his cohorts there that night was a reasonable inference from the evidence. There was abundant evidence from both state's witnesses and defense witnesses that there was disrespect exchanged that night, and that disrespect is not taken lightly in the community that gathered there at the club that night. Mr. Willis received a fair trial by a jury of his peers who were instructed both on first-degree and second-degree murder. And a conviction of the former, the first-degree murder, essentially invalidates the need for any instructions on lessers, such as voluntary or involuntary manslaughter here. I welcome the court's questions to either of those issues, be it the prosecutorial error or the instruction.
I have one question, but it's about the video, and
Yes.
you've seen the video, right?
Yes.
Okay, so where does, I'm going to call him by his first name because he has the same name as his brother, but where is James coming from? He's not coming from I couldn't really,
Right.
I watched it like 4 times, but is he coming from a car that's parked? You know, if this was the sidewalk and he was, you know, there's parking right here. Was he coming from a car over here?
When he's seen on the video pursuing Carter's
Right.
car, I believe so. His truck, I believe, had parked around the corner, 90 degrees to the sidewalk, if I recall.
Oh, okay.
And he had stepped out of that truck at some point and was down there in that area.
But he was never on the sidewalk, right?
As far as I'm aware,
Yeah, so
he
so
he
they're
was
having
further
to
back.
right.
away from the camera,
Okay,
right, in the distance.
right. I could, that's,
But
okay.
there are so many things that I wish were more clear in that video, but that's one of them.
Okay, thank you.
You're welcome. the showing of disrespect that the state argued was the motive for this killing. That argument was premised on abundant evidence that came from the form of Demetrius Parker, for instance. Demetrius Parker testified that whenever he's at the club, he keeps his head on a swivel because people start fights over nothing. He testified that respect is not given, it is demanded, you take it. That's from volume 27 of the trial. Antonio Frazier similarly testified that when there is disrespect shown among members of this community, they handle it right then. And he's testified, people at the club, quote, don't tolerate it. If someone disrespects, they are going to deal with it accordingly. That's from volume 30. Raekwon Robinson similarly testified that he witnessed the verbal altercation between Mr. Willis and Mr. Carter. And he saw Dale Willis sucker punch Mr. Carter out there on the sidewalk. And that's when Raekwon Robinson decided to leave because he knew the place was getting too tense. Several of the witnesses actually testified to leaving during this altercation because they were concerned about their safety. Tyrone Brown similarly testified he felt there was no point in sticking around at the club because most of the time, the way he testified, most of the time dudes get harder when they got that group. So the testimony was abundant that as tensions flared at the club that night, there were many people that were concerned about their safety, and there were many people that left because of that. And so the state's argument that Mr. Willis shot and killed Mr. Carter over a showing of disrespect was a reasonable inference. It was not impermissible inference stacking, as Mr. Willis argues now, because if you follow the sequence of events, you can see all of the facts that line up to this motive. Mr. Carter was inebriated. The testimony is that he was mouthing off to other people at the club, including Mr. Willis and his cohorts. That verbal altercation escalated when they were out on the sidewalk. When you put that in the perspective of all the testimony about disrespect not being tolerated, then when you see Mr. Dale Willis sucker punch Mr. Carter to the ground, and then Mr. Carter attempt to retreat, a reasonable inference is drawn from all of that the killing was done because Mr. Carter had shown James Willis's brother Dale disrespect that morning. This was not about inflaming the passions of the jury. It was about showing what the actual motive of the killing was. The state's use of the word crew to describe Mr. Willis and his cohorts there was not impermissible. It was not inflammatory. It was not unduly prejudicial, as Mr. Willis now claims. Crew is a relatively bland term. Of all the terms that could have applied here, it's not a loaded term like gang or cohorts or accomplices or co-defendants, as Dale Willis was to Mr. James Willis. And the state pointed out that the witnesses that testified on behalf of Mr. Willis that were part of his group, they all testified one way about the interactions. And that one way that they testified differed from the state's witnesses who were both cohorts, friends of Mr. Carter, and were others that were at the club that night that had no affiliation with either Mr. Carter or Willis. So that's why that argument was reasonable. Similarly, the state's argument on self-defense was very reasonable when put in the perspective of the entirety of the case.
Let me ask you about that.
Yes.
The one thing I'm hung up on is the closing argument. And the prosecutor saying that the defendant, that the jury had to believe the defendant over everyone else.
Yes.
That the victim had a gun. That isn't the law, right?
That's not the law, but that's not a statement of the law. As was pointed out in my colleague's argument, that was a statement about the facts, because Mr. Willis, when he pursued a self-defense theory of this case, it was premised entirely upon his testimony that he believed Mr. Carter had a gun that morning. No other witness testified about Mr. Carter having a gun. The car was searched. His person was searched after he was killed. No gun was found. No casings were found in his car that would have come from his gun. Only fragments and casings from Mr. Willis's gun.
But the argument is that it's the belief, not the fact that he actually possessed a gun, but the defendant's belief.
Right.
And isn't that where the problem lies in the statement?
I believe if you parse the words of the state carefully, it still didn't infringe upon the defendant's right to present the defense that he did. Because the way the state argued it was, in order to find for Mr. Willis and support his theory of the case and find self-defense applicable here, quote, you have to believe James Willis over everyone else that Jurel had a gun. And so the state's argument was you have to find some credibility to Mr. Willis's testimony that he believed there was a gun there that morning. You would have to give credence to Mr. Willis's testimony to grant him self-defense. And here is all the testimony on the other side of the coin that shows he didn't have a gun. And that the state's effort there was to effectively impeach Mr. Willis's testimony that he believed there was a gun. The state was refuting that. And the state also pointed out in the same sequence that Mr. Willis himself testified inconsistently about the presence of a gun, because he first testified that he pulled out his gun and fired on Mr. Carter after he heard shots fired. And then later on cross-examination, Mr. Willis testified he realized he better pull out his gun and shoot before Mr. Carter could pull out his. And so the state was highlighting these distinctions between Mr. Willis's own testimony, internally inconsistent, and also the inconsistencies between Mr. Willis's testimony and that of everyone else about the presence of a gun with Mr. Carter. And the state highlighted those inconsistencies in an effort to show that Mr. Willis's testimony that he believed there was a gun in Mr. Carter's possession is not credible, and that they should discount his testimony to that effect. Not that they should ignore it, but that they should discount it and find it not credible in the face of the overwhelming evidence to the contrary. And so that's why the state's argument on self-defense, I believe, was proper.
Could you get to the voluntary manslaughter instruction and on appeal? Why isn't it factually appropriate? Given how we have a sufficiency test that we apply, and given the defendant's statement, isn't that enough to get it factually appropriate?
I believe that's a very, very close question, whether or not it's factually appropriate. In this case, when all we have is the defendant's self-serving testimony and nothing else.
You've seen the cases, that's enough, isn't it?
It can be. And this court has also likewise said that a defendant's statement of his intent from the witness stand may not be enough to factually support an instruction on his preferred theory. The case to that effect was Calderon from 2000, wherein a defendant's self-serving statement of intent itself did not necessarily invoke a duty on the district court to instruct on a lesser form that carried recklessness.
That sort of predates our shift in how we have assessed factual appropriateness, though, right? To where it's more of a sufficiency.
It does appear to be more of a sufficiency case now. That's true. I don't believe as though this court has ever really overruled Calderon to that effect, or explicitly stated that Calderon is no longer good law to that line. But to the same extent that the self-serving statements here should not be enough, especially when they're so conflicted against all the other evidence. As I pointed out in the state's brief, the skip rule also applies to show how inapplicable this would be here, because the jury was instructed on both first degree and second degree. They did not opt for second degree. They did not opt for intentional killing lacking premeditation. They opted for a premeditated killing. And when the jury opted such, that essentially invalidates or it declares immaterial whether or not the district court instructed on still further lessers below second degree. And so this court simply cannot be firmly convinced that a jury would have checked the box for voluntary or involuntary manslaughter in this case, given that they were given an option between two higher level charges and they chose the highest one available. There's no reasonable way to read the jury's verdict that they would have stepped down to voluntary or involuntary manslaughter here. When, as I stated, the Cook case from 2008 talks about when the jury is instructed on first degree, then the correctness of instructions on voluntary or involuntary manslaughter effectively becomes immaterial. Willis's subjective belief about the presence of a gun was simply not credible. Internally, it was inconsistent, as the state has already pointed out. And on the involuntary manslaughter instruction that was raised on my colleague's argument just a few minutes ago, at most, Carter was engaged in a verbal altercation with Mr. Willis, at most.
With Dale,
I'm sorry?
with Dale.
With Dale, correct. With Dale Willis on the, up on the curb before James approached. But that verbal altercation does not justify the use by James Willis of any amount of force, much less deadly force. And so even if one believes that Carter antagonized Dale Willis and shouted whatever he did at him, that still does not justify James Willis's use of any amount of force. And as the Justice Rosen already pointed out, under 2252-26, self-defense is not available to one who initially provokes force, initially provokes the altercation. And that's effectively what Dale Willis, the co-defendant of James Willis here, did that morning when he sucker punched Carter right before Carter attempted to retreat. There was an abundance of premeditation in this case. It goes back into the hour before the killing when the text went out from Dale Willis at the club saying, "Emergency, bro, need you here," and prompted James Willis to text and call all of his friends, letting them know an emergency existed at the club and he needed to get there effectively to protect his brother. Recognizing I'm out of time, I'm happy to stand for any further questions by this court. Absent those, I'm asking that this court affirm Mr. Willis's convictions and sentence.
I see no questions. Thank you.
Thank you.
Ms. Patty, you reserved 3 minutes.
And unless there are any further questions for me, I'll yield.
I don't see any. Thank you.
Thank you.
Thank you to both counsel for your arguments this morning. The court will take this under advisement. Again, to explain to the audience just a little bit about what that means, the court later today will conference the cases that we hear today, and we'll continue discussing those until we have reached a preliminary decision, which time one of us will be assigned to write a draft decision representing the majority view of how this case should be resolved. There may be people who disagree, in which case there could be separate opinions that the disagreements could vary. One option would be that they just disagree with the reasoning, but agree on the result. In that case, it's called a concurring opinion. Sometimes they can disagree with the result, in which case it would be a dissenting opinion. Those draft opinions are then circulated to all of the members of the court. We read them carefully, we comment on them, we make changes based upon those comments, and those back and forth continue until the court is comfortable with releasing the opinion. Our decisions are filed most often on a Friday morning. A press release is issued at that time, and the decision is put on our website, the KS Court's website. So it's available for everyone to read, to understand the rationale and the reasons that we reached, for our decision. We try to explain that so that people do understand that. I would note that as you compare the 3 branches of government, this is one of the things that contrasts us to other branches of government, in that although there are occasions the other branches explain the reasons behind their decisions, they don't do it as regularly or as with as much length, I guess, in the explanation, generally is what you find with a court. So the courts are transparent in that way in setting out that thought process. So anyway, with that, thank you, counsel, for your arguments today. We'll now call 125-846 State of Kansas versus Benjamin Ballard. Counsel.
Good morning, and may it please the court. Grace Tran on behalf of the appellant, Mr. Benjamin Ballard. Benjamin was charged with failing to register as a transient offender during the month of September 2021. However, the state's own evidence showed that Benjamin was not actually transient during that month. The state had submitted a form to the jury that showed that Benjamin had put his brother's address as his current physical residence. And also, Benjamin's brother testified that during that month, Benjamin lived with him and he slept on his couch every day. Under Cora's definitions, Benjamin was not transient during that month. He resided at his brother's house. Because of that, Benjamin's conviction should be vacated because the state failed to put on sufficient evidence that Benjamin was transient. But even
Why
if this,
isn't Lena Kastner, the employee who testified, why aren't her statements that he reported that he was transient, that statement alone, that evidence alone, sufficient to put this matter before the jury? I understand the defense would have put on, no, that isn't what the evidence showed, but her statement that he was transient, isn't that prima facie evidence of the?
Your Honor, no, it isn't, because to get there, we have to look at the definitions of transient, residence, and resides in Cora. And the fact that Lena Kastner said that Benjamin told her that he was transient, that doesn't comport with the other evidence that had gotten put forth, which was the fact that at that very same time, he told them, as evidenced by the forum, that he was living, his current physical residence was his brother's house. So the fact that Benjamin thought that he was transient, or Lena Kastner thought that he was transient, it's not relevant when the actual evidence that was put forward does not comport with Cora's definition of when someone is transient.
There might have been objections, but none were made. So it came into evidence. So the jury has heard the defendant's own belief that he was transient. And it sounds like there are reasons to impeach that or reasons to explain it away. But the fact that those reasons exist, is that enough to change the sufficiency analysis?
Yes, Your Honor. Our argument is that even with all of the evidence, even with Lena Kastner saying that Benjamin told her he was transient, none of that actually matters because under the statute, he wasn't actually transient. Transient, according to Cora, means that they have no fixed or identifiable residence. And all of the evidence showed that he did in fact have a fixed residence. And I think this gets to the difficulty with the definitions of transient, residence, and resides in Cora being different from a common understanding of what we would consider when someone is transient. Because the average person, such as Benjamin, I don't think would consider having, 3 different definitions that are all intertwined with each other, 120 words, to describe whether or not they are transient. And so I think it's understandable that Benjamin could have possibly thought that he was transient, and indeed that the jury could have thought that he was transient. But the fact is that under the statute, the evidence did not show that he was transient because the state's evidence showed that he did in fact have a fixed and identifiable residence, which was his brother's house.
One other question on that. I know that she testified that he reported that he was transient, but that's kind of a legal conclusion, because what he actually said was, I walk around Broadway and the Lord's Diner, right? I mean, he didn't say, oh, I'm transient, or I don't have a home. He just said, I walk around Broadway and the Lord's Diner. He didn't say where he sleeps, right? Or did she testify that he said, I'm transient?
I believe the testimony is that Lena Kastner says that he reported that he didn't actually, quote, reside at his brother's house and that he did walk around Broadway and the Lord's Diner. But again, I think that using these terms like reside, transient, I think maybe there was other testimony that he said he reported that he was transient. Like you said, those are legal conclusions. And I think.
And one of the places that he said he could be found, besides the Lord's Diner and Broadway, was his brother's address, right? On that same piece of paper.
Right. On that same piece of paper, under the current physical residence, that was what he listed was his residence at that point.
To Chief Lukert's question, does it matter if she was wrong about what he reported if there was no objection?
For the sufficiency of the evidence analysis, I don't think it matters whether there was an objection or not. There doesn't have to be an objection to preserve that when this court is looking did the state meet its burden to prove beyond a reasonable doubt that he was in fact transient? And when we look at the statute, he has a fixed and identifiable residence, so the state did not meet that burden. There was no evidence to the contrary, legally speaking, that he did not stay, sleep, or maintain his person at his brother's house during that period, and that's what the statutes require.
But can we assume that that's the only place that she got the information if she testifies that this is what he reported? If there's no objection, don't we have to take that as evidence that he said that? Or that he did that?
I think it's perfectly possible for Benjamin to have reported that he was transient to Lena Kastner. But as Justice Standard said, that's a legal conclusion, whether or not someone is transient. And so I think, so if we imagine the situation in reverse, Kansas appellate courts have said, when an offender has a good faith belief that they do not have to register as an offender, that doesn't matter when we look at that. And so if someone had thought, I don't have to register, we would not be here talking about that today. But I think the same applies in the opposite sense here, where even if Mr. Ballard and Lena Kastner and Deputy Clopton, they all have a good faith belief that Benjamin did have to register as a transient, it still doesn't matter if legally speaking he wasn't transient, and that's what all of the evidence showed. So Benjamin can think he's transient, Lena Kastner can think he's transient, but all of the evidence showed that he lived at his brother's house. He put that down on his form. Nowhere did he say that he did not, sleep or maintain himself there for multiple days or parts of days. So all of the evidence showed that he resided at his brother's house during that time period.
And I suspect this question is very intertwined with your second argument about the jury not being properly instructed. But it seems to me that you are really asking us to reweigh evidence, because this jury apparently did not find credible the brother's testimony that he was residing with, that his brother was sleeping on his couch, and he considered that to be residing with his family during that time period.
And Your Honor, it's our argument that we are not asking this court to reweigh the testimony. The Court of Appeals did speak a lot to the fact that the jury must have just not believed his brother and must have been a credibility determination against the brother toward the sheriff's office staff. And Benjamin's contention is that because it's not a credibility determination, because like you said, this goes toward the instructional issue, which is that it's incredibly possible that the jury didn't think that John's testimony or the state's evidence, the form, established that Benjamin had a residence because they weren't instructed on the actual legal definition of what is a residence. And so, like I said before, Hora's definitions of transient, of residence, of resides are not common sense toward what the normal average person would think of as a residence. The jury did not hear that if the person stays, sleeps, or maintains their property in a location, they reside there. There's a presumption that they reside somewhere if they stay, sleep, or maintain themselves there for 3 or more consecutive days. So it's quite possible, not necessarily that the jury thought that Benjamin didn't have a residence because they didn't know what residence actually means in this context. And so it's not a credibility determination, it's a legal determination that the evidence presented established a residence, established that Benjamin wasn't transient, but because Hora's definitions are not self-evident to the average person and what they would think of when someone is transient, the jury was not able to adequately weigh that question because they simply did not have the tools. And that goes toward the instructional issue that the jury should have been instructed on those terms because, again, the terms are not, or the statutory definitions in court are not really self-evident. They're very complicated, they're very long. The average person could think, okay, if someone, and as the state's witnesses testified, if someone doesn't have a permanent place to stay or a permanent address, that they could be transient. And it may very well be true that this was not a permanent place to stay or permanent address for Benjamin, But that's not what the statute requires. The statute just requires a fixed or identifiable residence.
Can I ask you a question that may sound a little academic? I'm not even sure I'm not even suggesting it could be outcome determinative here, but I think it's important for criminal appeals in our state. The Court of Appeals looked to whether your requested or the proposed instructional language to be added was legally and factually appropriate. And they concluded it was, right? And that was the test they applied for sort of the error analysis. But our precedent has suggested that when you are dealing with omitted language, you're not going to get every legally and factually appropriate instruction. So we look to the instructions that were given as a whole to see whether they accurately state the law or were likely to mislead the jury. And that's a different error test than when you're talking about assessing instructions that were given for factual and legal appropriateness. Do you think that what I've suggested is the correct legal standard for assessing error with your issue?
I believe so, Your Honor. And I believe in our brief, we argued that sort of along the same veins as we've been speaking, that the jury instructions that were given as a whole didn't adequately represent the law to the jury and were likely to mislead them because, again, the definitions are just not intuitive. They're not common sense definitions that the average person would understand.
Right. The test fits your argument well, but that is the test as opposed to just whether it's factually and legally appropriate. And that alone would demonstrate error. That's not the case, right?
That my understanding is that's the case, Your Honor.
Thanks.
Is there any place in the record that the jury was, through counsel's argument or otherwise, told about the statutory definitions?
There weren't any specific arguments toward the statutory definitions. I do believe one of the state's witnesses had given the jury some definitions that were closer maybe to what the statute requires. Ryan Hansen, I believe of the KBI, said that a transient offender has no known physical address or doesn't have a fixed physical address, which maybe gets us a little bit closer to what the statute says. But in the face of multiple other statements by the state's witnesses, I think that those definitions are outweighed by just the weight of how many times the jury was told definitions of transients that were just not what the statute requires. And I see that I'm out of time. I would stand for any questions.
I see none. Thank you.
Thank you.
Mr. Gillette?
Thank you, Chief Justice. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'll take these issues in the order that they were presented in the original brief today, beginning with the sufficiency of the evidence. And it is the state's position still today that the defendant, even from the podium, is continuing to ask this court explicitly to just reweigh the evidence and credit his brother over everything else. And that is not appropriate under this court's standard of review, which requires the court to review the evidence in the light most favorable to the state without conducting such reweighing. Here, the state does believe that the evidence was overwhelming, and I want to summarize that and emphasize one particular point, what the evidence did show. The defendant was required to register as a result of an Arkansas conviction that required him to register once he came to Kansas. He was required to register in the months of January, April, July, and October. In July, the defendant registered as appropriate and had his picture taken. That fact and that evidence was presented to the jury. Prior to August of 2021, the defendant, in fact, did self-report to Ms. Kastner that he was transient and he did not reside at his brother's house, but that he went there during the day.
Can you give me the record site for that? And what is her exact testimony?
I cite in my brief, it's record volume 5, pages 151, 156, 159 to 60, and 165.
And so,
as well as State's Exhibit 2, sorry.
So this is more than, somebody marked him transient in the system. Okay. But when asked about that, this is more than he wrote locations where he could be found during the day?
I want to back you up one step because that was
Okay.
the next point that I want to emphasize.
Okay,
Why was he there in August? If he's not transient, August is not a month that would require him to report under Cora, period. He was there in August and he completed a transient offender registration form that was explained that while he listed his brother's address as a current physical address, that is a common thing that happens, that this is maybe where they might most likely be found, but that they are then required to list other places where they frequent. And in this case, it was walking around on a street in Wichita and frequenting a charitable kitchen.
but does it say on there where he could be found during the day? I mean, it looks like she testified this is where he could be found during the day on the change information form.
I would have to look closer at
Okay.
that form, and but I think it explains I think her testimony was pretty self-explanatory. That he was there specifically. She testified, defendant, he was transient, which is how anyone would have to report it. And that was actually, I can narrow that down. It was volume 5, pages 159 and 165.
Well, that's where she says he's transient.
He reported to her that he was.
Okay, and then
He registered.
that's 154 and 55.
159 and 165.
Right, but that's where on 159, he says, that it was based on this 152, 151 and 152. He was considered transient because he wrote locations where he could be found during the day on the change of information form, which is during the day I walk around Broadway and the Lord's Diner. That's at page 151 and 152.
And I think it's my review of 151, and as I have set it forth in my brief, the defendant's transient registration lifted, as I said, a quote, current physical residence at his brother's house, but it included his notation, I walk around Broadway and the Lord's Diner. Ms. Kastner then explained that defendant told the offender registration unit he did not actually reside at his brother's home, but that he went there during the day. And that was at record volume 5, page 160.
Page 160.
Correct.
Okay, whether or not one is transient is a conclusion, right? I'm transient. That is a conclusion based on something.
Correct.
Okay, how much confidence should we have that the jury would not have made a different decision if they had understood the 3-day, if they had been advised of the 3-day rule and the 10-day?
I'm going to answer that in 2 ways. And my first answer is, I don't know what the defendant wanted the jury to be instructed on, because at one point it was the statutory definitions, but in his petition for review, it's something totally different. So I don't know what exactly the defendant was wanting the jury to be instructed upon here. And my second answer would be that I have the utmost confidence that this wouldn't have mattered. That's the clear error standard of review here. If these instructions had been given, the jury would have, to have acquitted, they would have had to believe defendant's brother over everyone else. They would have had to conclude that defendant resided, and I'm just going to use the statutory language because that I think is what is the most important here, that he maintained with regularity or temporarily his person and property. There was no evidence that he had any property at his brother's home, not even from his brother. Let's see. And then that leaves us with just the presumption that could have maybe been instructed upon. And the presumption that the statute provides is that an offender resides at any and all locations where the offender stays, sleeps, or maintains the offender's person for, and this is the important part, 3 or more consecutive days or parts of days, or for 10 or more non-consecutive days in a period of 30 consecutive days. Even with that presumption.
That's in the statute?
Yes.
Okay, and so was that provided to the jury?
No, and it wouldn't have mattered even if it had been, because there was no evidence that the defendant that the presumption would have applied.
I thought the brother testified that he slept
there
at his
every-
house, slept on his couch, his brother's couch, through
Every,
the month of September, up through his birthday, which was October 4th. You remember that very clearly, that that was a date that he took his brother, drove his brother to register because it was his birthday and he remembered it. And then shortly after that, the sister-in-law loses her patience with the situation and says he can't stay there any longer. But the way I read the brother's testimony, it's a fair inference that he was there most of September and the first part of October.
What I would suggest is that what Your Honor is positing is essentially reweighing the brother's testimony. His
Well,
brother's
yeah,
testimony was not that clear, with all due respect.
Well, I'm
Again,
just suggesting that there is something there. I don't, so to
Sure.
push back on that.
So I guess my
What
pushback,
bothers me from this is perhaps the misleading part of this without the jury instruction, because you had the state's witnesses. Granted, I think the KBI representative did use close to statutory language, but the two witnesses from the sheriff's office both repeatedly referred to, he didn't have a permanent residence. He didn't have a permanent residence. And then I was just curious how that was argued, and looking at the state's closing argument, that's what the prosecutor argued. The prosecutor repeatedly told the jury he was a transient. He had no permanent address. That was said at least twice. So why didn't that mislead the jury to think that what they needed to look for was a permanent address?
I do want to start with one point regarding the brother's testimony, and then I will directly answer Your Honor's question. And that the brother's testimony began that the defendant only was with him on and off during 2020 and 2021. At another point, he was pretty much from August till October, he was there. Then he tries to clarify, then he tries to hone it down. Then it's just, he was asleep on my couch every day. I remember that. And that is what the jury found to not be credible. So anything that goes against that, or that would find John's testimony credible, is something that this court can't do under its analysis. And then in regard to whether or not this would have been misleading, it wouldn't, because nobody legitimately disputed that the defendant was transient. He had his brother testify that maybe he was there some of the time, but that clearly was not credible.
What was the evidence of where the defendant slept from the state's perspective?
From the state's perspective, the evidence of where the defendant slept from the defendant's own mouth was that there was not a clearly identifiable place that he was.
No, I'm not, you keep, I mean, it appears to me at least that you keep flipping the burden of proof, like the defendant didn't come forward with evidence, et cetera. I mean, the state still has the burden to prove transience. So what was the evidence the state put before the jury that this defendant did not have a fixed or identifiable sleeping place during this time?
I guess what I would say is that just sleeping somewhere doesn't.
What is it? Should I construe your answer that you didn't have any evidence?
No, you cannot.
Well, then what is the answer? What is the evidence that the state put on about where this defendant slept during the relevant period?
I guess my first answer would be, I don't know that simply where someone sleeps is relevant to whether or not that is a residence. But my second point would be that the defendant himself reported to the offender registration unit that he was transient. He appeared in August. He wouldn't have to otherwise. He claimed to have appeared in September. He wouldn't have to if he wasn't.
I understand those are all, you can, I suppose, have the sort of thinnest of inferences if you presume the defendant has a proper legal understanding of what it means to be transient. But I'm asking about concrete evidence. Was there any?
Was there any concrete evidence from the state's perspective of where the defendant was laying his head at night? Concrete evidence, I don't think that there was. But again, at the end of the day, I don't think that matters here.
Why not? That's what the statute talks about.
Well,
sleep.
That's one of the things that can leave
Would
something-
you agree with me that if this defendant in fact slept at his brother's house every night, I mean, I don't even think that every night's required, but if he did every night, that he would be, as a matter of law, not transient?
If the defendant he would have to, for his brother's house to have been his residence, he would have to maintain his person and property there, number one.
No,
If it-
the statute says stay, comma, sleep, or maintain with regularity one's person and property.
Correct. So he would have to have slept there, his person with his property there, for there to have been direct evidence that was his residence. The only other thing, again, that we would have reached would have been a presumption, which the state continues to assert was easily overcome by.
I'm not even talking about the presumption. I just think in order for the state to prove the element of the crime, doesn't the state have to put forward evidence that he did not sleep in the same in an identifiable place over this period of time? That's what the statute says.
The statute says to stay, sleep, or maintain. I mean, I could stay here for a few hours. I could go take a nap in the attorney's room. This isn't my residence. And that would be tumbling down a whole nother definitional rabbit hole that I don't believe was necessary based on the evidence that was presented here, which was that John, the brothers, the only one that gave any indication that the defendant was at his home with any level of regularity, and the jury explicitly, clearly found that to have not been credible. The credible evidence was the defendant's statements to the offender registration unit that he's transient.
Yeah, the credible evidence was a bunch of conclusory statements made by the defendant himself and other state officials, and then people testifying, all to the legal conclusion that he was transient.
And doesn't even the defendant's statement support this definition? Because he said he didn't sleep at his brother's house, but he stayed there during the day. He went there during the day, I should say. But when the fact that he said he went there during the day, isn't that the definition of stays at a particular address?
I don't think so. To go there, you have to keep your person and property there, and that's where I would circle back.
No,
to
that's a disjunct, there's an or, right?
Sleep or maintain with regularity or temporarily one's person and property. There was no evidence that he kept any property at his brother's house at all, ever, not even from John.
Did he have any property?
He at least had some clothing that we know because of his photograph that was attached. We know
Clothes that he was wearing?
We know at least that, because this was not the issue at trial.
Yeah.
That's the other thing that we continue to run into, is that if there'd been anything presented to press this, perhaps there could have been additional.
Whose burden
evidence.
was it to present this?
It's the state's burden to present evidence to satisfy its burden of proof. But I believe that the evidence here did.
I want to probe just a little bit about the inference you're asking us to draw about his having to report in August. As I understand KBI Representative Ryan Hansen's testimony, he explained that the local agency, in this case, the Sedgwick County Sheriff's Office, could just tell an offender, you have to report at a more regular basis. And as I understood the testimony of Lena Kastner, they did tell him that he needed to report monthly. So does that really allow us to draw an inference other than they ordered him to report? And he did? At least for the month of August?
I guess I'm not as familiar with the point in Mr. Hansen's testimony that you're talking about, because the points, and I guess it's partly because his testimony was just basically an overview, and the focus of his testimony was he gave a couple of definitions and then explained that transient offenders are required to register every 30 days. That was record volume 5, page 131. Again, I don't see anything here that would have said.
And unfortunately, I can't give you a record citation. It's just kind of my memory of as I read it, read that testimony. And I did not look at the statute, to see if there was any support for his testimony, but
Then, and fair enough. And I mean, I think it's also relevant to point out Clopton, the deputy's testimony was that he's the one that really explained that the defendant's listing of an address was just because he stays there from time to time, but otherwise he's homeless, at which point they provide free locations where they frequent, sleep near, intersections, shelters, etc. His was one of those. These folks knew the defendant and they knew that he was transient. The defendant knew he was transient. And any argument to the contrary at this stage is simply one that is asking for the evidence to be reweighed in this case. If there are no other questions, I would ask, I mean, if there are any, I would take them, but if there are not, I would respectfully ask that this court uphold the defendant's conviction for failing to register in September of 2021. Thank you very much.
thank you. Ms. Tran, that last statement prompts a question. Just a clarification. You are not challenging the conviction for the October failure to report. Is that correct?
That's correct.
Okay, so it is just September we are focused on.
Just the September, the one where he was the transient offender conviction. And if there are no other questions, I would waive my rebuttal time.
I have a question about the form that the Mr. Ballard filled out. He listed an address and I believe it was in response to what's your residence or where do you live? Is that correct?
I'm not certain what it was in response to, but it is clear that he did list the address.
And that was his brother's address? correct?
Yes,
And then the box that he wrote on was, during the day I go, I often go here and here, correct?
correct. So it says, it's a blank box and it says, I walk around Broadway in the Lord's Diner on the form.
What's the question above it?
There is no question above it. It looks like it's kind of just like a blank box for extra information. There's
It just, is that what it says? And I could look it up, sorry, but does it just say extra information or anything?
it doesn't say
in the box?
anything above that on the box.
So he
It's
was a
completely
volunteer.
blank, and then at
Blank.
the bottom, it says, I walk around Broadway and the Lord's Diner, and then there's a black line, and below that is the signature block.
Okay, is there anything in the box where he listed the address?
The box states current physical residence and then street, apartment number, city, et cetera.
And that's on the other, that's on the
That's on the
That-
first page.
page.
And that's where he listed
That's
the
typed in.
address.
That's where he listed.
That's typed
Okay.
in.
Thank you, thank you.
Thank you. If there are no further questions, we would ask that this court vacate Mr. Ballard's conviction. The state did not prove beyond a reasonable doubt that he was transient. But even if this court does find that there's sufficient evidence, Mr. Ballard should still receive a new trial because the jury wasn't instructed on CORE's definitions of transient residence and residence. Thank you.
Thank you. Thank you to both counsel for your arguments. The court will now be in recess until 10:30.
All right.